This is Professor Porter, and again we're talking about the Federal Rules of Evidence today, and specifically Article 6 concerning witnesses. And really what Article 6 gets at are the modes of impeachment. That is the way a cross-examiner can attack the other side's witness and go after their credibility. We all understand if there are facts favorable in the file or facts favorable in the witness's prior statements that we can elicit favorable facts to our side, but there are also instances when witnesses have credibility problems or avenues we can pursue on cross-examination to have available to us in closing the ability to argue that someone shouldn't be believed, to argue that their testimony should be discredited either in whole or in part. And here are the avenues. And what I want to explore is both those avenues that are available from the common law and also available from the rules. And the fact that all of them feed down into and only go to one thing. They all go to credibility, they all go to character for untruthfulness. And before I get into the specifics, I want you to think about what's different about Article 6 and some of these rules and these avenues of impeachment. What's different from the other rules? Article 8 having to do with hearsay, or Article 4 having to do with character evidence. They both are thou shalt not rules, right? Article 8 in hearsay says, thou shalt not bring in out-of-court statements that are offered for the truth of the matter asserted. Don't do it. That's what the rule says. Article 4, specifically 404A, says character evidence is bad. Anything where evidence is offered to show propensity, anything where evidence is offered to show that someone acted in conformity with a character trait on the day of the events of the case is bad. They are thou shalt not rules. They say thou shalt not, don't do it. Article 6 is different. The rules that allow for some of these avenues say what you can do. They say what's permissible. So really, as the objecting party, I have to think, when I object, Your Honor, objection, improper impeachment, that's the proper objection under Article 6, what I'm really saying is, while there are these avenues that are available to the cross-examiner to explore credibility, to explore someone's, attack someone's character for untruthfulness, this cross-examiner is not on one of those proper paths. This cross-examiner is outside of the box of the modes of impeachment. There are modes of impeachment, and they're doing it wrong. Your Honor, objection, improper impeachment. Let's talk about some of the specific ones. The first three, memory, perception, and bias. They don't really have a place in the rule. There isn't really anything you can point to. But clearly we can ask any witness, you weren't wearing your prescription eyeglasses. It was raining that day, you couldn't really see things. Those questions go to perception. You were drinking before you came to court today. You're on medication for depression. Those questions go to memory, our ability at trial to remember events from the past. And lastly, we all understand bias questions. Anything that goes to something that would color someone's testimony or motivate them to testify in a certain way. You know the criminal defendant. You are being paid for your testimony here today for experts. We understand that type of testimony. Those are allowed. They're under the rules. If you get an objection like objection, improper impeachment, or even objection, relevance, your response is, I am permitted to do this. This goes to perception. This goes to bias. Now let's look at some of the ones that are in the rules. We all understand that convictions and exploring specific acts of untruthfulness are allowed under the rules. 609, I don't have to go into all the specifics of 609, but there are certain convictions, crimes of dishonesty, and or felonies, depending on whether the witness, with a different balancing test, depending on the witness is someone other than the criminal defendant or the criminal defendant themselves, that we can explore as a mode of impeachment. I can ask some witnesses about some prior crimes that they have in their past. Why? Because the rulemakers say it goes to character for untruthfulness. It goes to that witness's credibility. The same thing with specific acts of untruthfulness. Lying on an application, lying on submitting a false tax return. Those things are specific acts that speak to untruthfulness, and 608B allows us to explore some of those. Again, they go to the character for untruthfulness. They go to the witness's credibility. Think of these are all questions that come out on cross-examination. And the most obvious one and the one that comes up the most is prior and consistent statements. We have to have a contemporaneous conversation with the witness today. We have to ask them what they did or what they saw first before we can go to a prior statement. You can't launch into someone's deposition. You can't launch into what they told the police. But if they stray from that version, if they stray from that safety net, then we understand prior and consistent statements is a way that we can attack someone's credibility and their character for untruthfulness. These are the modes of impeachment. This is what Article 6 is about. This is how we know what people are able to do and what they're not able to do. I hope this helps.